Hello, everyone, and welcome to the channel, Ontario Law and the Older Person. This is going to be about elder abuse, a kind of elder abuse called predatory marriages. Now, right off the top, I can let you know we're not going to be getting details of any kind of physical abuse. It's more about emotional abuse and manipulation. Predatory marriages haven't gotten a lot of attention in the past, but it is probably something that's going to get more discussion as we go along, and older people are engaging in second marriages or third marriages. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decision should be made based on this material. Any viewer who needs legal advice should contact a lawyer. What is predatory marriage? I like the definition given on this website from Friedman Estate Litigation, and the link is in the description. Predatory marriage is a form of elder abuse that occurs when an older individual, typically someone who is mentally or physically vulnerable, is deceived or coerced into marrying another person with ulterior motives. So that's a direct quote from the site. I just want to point out it's not necessarily involving an older person. It could be anyone who might be in a fragile or vulnerable state. It's just that in these circumstances, older people tend to have more money. Another quote, these motives often center around financial gain, gaining access to the victim's assets or property, or securing inheritance rights. In many cases, the perpetrators of predatory marriages may exploit the victim's diminished mental capacity or emotional vulnerability. So the thing is, this isn't about marrying someone for money. So sometimes people kind of come up with a deal. I provide you with this and you provide me with a billionaire lifestyle. And, that's fine if everyone has their eyes open and they know what's happening. This is a situation where someone is targeting someone because they're vulnerable and then involving in emotional exploitation or things like isolating these people from family members and other sources of information. So this attempt to overwhelm the will of the other person is what kind of separates this from regular marriages for the sake of money. It's important to note that the capacity required to make a will is generally considered to be higher than capacity to enter into a marriage contract. In Ontario, as in many other jurisdictions, the legal requirements for marriage capacity are relatively low compared to those of making a will. And that makes no sense to me at all. A marriage has enormous legal repercussions in so many areas of law. So, for example, estate law, tax law, family law. Like it's just can go so far across the board of other laws. So people should be expected to have a thorough understanding of what they're doing. This is an interesting article about this issue. It's called Predatory Marriage, an Emerging Medical Legal Issue. And those are the names of the people who contributed to this article. The link is in the description. A direct quote from the article. The number of seniors has more than tripled in Canada in the past 40 years, with those aged 75 and above growing at the fastest rate. Many more individuals with higher net worth will die in the coming decade than in previous ones, which is grim. I just added that little reminder. This also does mean more people over the age of 80 and more people over the age of 100. So those are pretty big numbers. And a lot of seniors, so they're living longer lives. All those years good years? Another quote, greater wealth provides the incentive for would-be predators motivated by financial gain. At the same time, the population of those at risk due to conditions that may impair capacity in their later life, especially dementia, has also increased. And of course, we see that with a lot of scams being targeted directly to older people more than young people. So they're often called grandparent scams, things like that. Another quote, it is practically difficult to prevent a marriage since there is no clear process for determining capacity when a marriage license is granted, and since predators often hide their intentions or isolate the victim, such that there is rarely knowledge of a marriage in advance. Okay, so anyone who gives a license or performs a marriage ceremony has the legal obligation to be comfortable that the people getting married have the capacity to make that choice. So recently, I contacted 10 organizations that involve people who perform marriage ceremonies, some religious, different religions, and some not religious. And I asked what kind of training they got to evaluate capacity. Of the 10, only one responded, and the answer was basically that there wasn't any. That's a bit alarming. Just a quick look at the Marriage Act. I'm going to show you where that legal obligation is stated. We find this in Section 7. No person shall issue a license to or solemnize the marriage of any person who, based on what he or she knows or has reasonable grounds to believe, reasonable grounds, lacks mental capacity to marry by reason of being under the influence of intoxicating liquor or drugs or for any other reason. I am going to give a lot of attention to this one case, Banton and Banton. It's an older case from 1998, and laws have changed a bit since then, but it's still considered an important case when talking about predatory marriage. Now, any rational person would see that this was a situation of predatory marriage, but one of the reasons I like to talk about this case is because the judge's decision was bonkers. This was clearly a case of abuse, and the decision by the judge was totally unjust. So it's an example where, judges can be irrational as far as I'm concerned. So I just want to raise this. In 1998, in Ontario, when a person married, their will was automatically void unless the will explicitly stated that it was signed in contemplation of marrying a particular person at a particular time. This is no longer the case. And unfortunately, a lot of people didn't know that when they got married, their will was thrown out. And then we would have difficulties along the line. And this is why you want to make sure people know what they're doing. They need to know what the repercussions are when they get married. This is actually a very lengthy case, and there's a lot going on. I'm just plucking out what I think are the essential details in order to understand the case. So here is a very brief list. I will be elaborating to some extent. So a young woman, Muna, targeted an older man, George, for marriage. The older man wrote a will and powers of attorney in the woman's favor. She isolated the older man from his adult children. And upon his death, the children are challenging his capacity to make those legal decisions. Here we have paragraph 9 from the court decision. Lily, George's wife, died in June 1994. By at least the end of the following month, and probably earlier, George Banton had formed a friendship which quickly developed into a close attachment with the applicant, Muna Yassin. I'm not sure if I'm pronouncing that correctly, a waitress in the restaurant at Lifestyles, where George lived. Muna was 31 years of age. So seriously, someone swooping in when the most obvious heir dies. And look at that timeline. I can make a bad joke about things not being cold yet. This is weird. Red flag. In July of 1994, Muna was hired by George to provide care and companionship. The court decision says George was to pay her $10 an hour. So here we have, very quickly, a much more personal relationship and George becoming reliant on Muna. In December of 1994, George and Muna got married without telling his children and with only two witnesses. So this was kind of a hasty marriage and they're keeping it a secret. But I also want to point out that George's children were also engaging in dicey stunts, highly technical language there, with his money without telling him. So unfortunately, he had a number of people around him who were making decisions that were not in his best interests. 2 days later, December 19, George and Muna went to a lawyer's office, where George explained he wanted a new will and a new power of attorney, giving that authority to Muna. On December 20th, the lawyer was told the entire estate was to go to Muna. The documents were prepared and George signed them on December 21st. So what do we have? We have a drastic shift of testamentary intent. The person benefiting was always there, and this is a crazy timeline. Very, very short, very quick. What was the lawyer thinking? And the problem with basically cutting corners this way, yes, it makes the documents easier to question and challenge. The issues boil down to, did he have capacity to marry and sign the will? So remember, we have a different level of capacity needed to marry and sign a will. So those are two different issues right in that category. And then, was he subjected to undue influence under Muna? So when it came to the will, and they mostly discussed just the will and the marriage, not necessarily the powers of attorney, the judge found George had the capacity to draft this will. And I think that's ridiculous. If you were to read the case, you would see that he is totally out of touch with the nature of his assets, thinking he was super rich when he wasn't, and a bunch of other lack of information gaps in his knowledge. So to me, this means he can't understand what the decision is and appreciate the results of that decision. However, due to his vulnerable mental and physical health, he was vulnerable to Muna's influence and made choices he normally wouldn't. So finding that the will is invalid due to undue influence. Paragraph 136 from the court decision. In late September and early October 1994, George Banton had tried to resist Muna's attempts to seduce him into marriage, but in November he capitulated and consented to it. Although I have also found that marriage was part of Muna's carefully planned and tenaciously implemented scheme to obtain control and ultimately the ownership of his property, as far as the marriage was concerned, he was, at the end, a willing victim. And shortly thereafter, he told Victor, that's one of his sons, that he had wanted one last fling. A willing victim. I'm sorry to get all snowflakey here, but I find the very concept of a willing victim deeply offensive. There's no such thing. This woman swooped in on this man immediately after his wife died and wouldn't take no for an answer until he gave in. So I usually don't like the whole gender flip thing, but if a man did this to a woman, would anyone be this lackadaisical about it? Look at the words the judge is using. Scheme. Tenaciously. Like there's no such thing as a scheme that's, good for the person who's, experiencing this scheme. I find the judge's opinion in this so bizarre and disturbing. This is paragraph 132 from the case. Mr. Allen, the Reverend who married George and Muna, testified that he was aware of the prohibition in the Marriage Act, citation, of marriages of persons who are mentally ill. He stated that he had no concerns at all about George Banton's mental condition. I just want you to look at Section 7 of the Marriage Act again to remind you what it says. So it says, no person shall issue a license to or solemnize the marriage of any person who, based on what he or she knows or has reasonable grounds to believe, lacks mental capacity to marry by reason of being under the influence of intoxicating liquor or drugs or for any other reason. Nowhere in there does it say mental illness. Having a mental illness does not mean someone lacks capacity. This is not an automatic assumption from one to the next. So it seems to me that this reverend might not even understand the nature of the legal responsibility he's supposed to be upholding. Back to paragraph 132. He, the Reverend, said he remembered George as being quite a good conversationalist and that there was nothing to indicate that he did not understand the purpose and nature of the ceremony. Mr. Allen also saw no signs of depression and nothing to suggest that George was afraid of or being manipulated or controlled by Muna. Mr. Allen testified that he left immediately after the ceremony and did not participate in any reception or party. So here's the thing, we don't have enough information from the decision to know whether Mr. Allen had ever met George outside of this very short period of time. And then he said he did not see a walking frame or canes, and he made no mention of any hearing disability or hearing aids. So this reverend is equating physical issues with capacity. That is very disturbing. His conclusion about George Banton's mental capacity appears to have been formed on the basis of George's general demeanor and his answers to the questions in the service, rather than from any questions asked specifically for that purpose. Just a little side quest here. I'm bringing your attention to this article, The Role of the Medical Expert in the Retrospective Assessment of Testamentary Capacity. The link is in the description. For the most part, it's not really relevant to this particular case, but it has an interesting idea in it that I would like you to keep in mind if you are thinking about this case. This goes under the paragraph, the interpretation of lay evidence videos and preservation of social graces. So the preservation of social graces is what's relevant to our discussion, but I do want to touch on what lay evidence can mean. So a lay person is a person who is not a professional or expert in the discussion right now. So for example, if you have healthcare providers talking to each other about healthcare stuff, then people who are not in that role would be a layperson. Lawyers talking to each other about law stuff, someone who doesn't have legal experience or expertise, they are a layperson. And in fact, the whole concept of someone being a layman is from the idea that clergymen were the people who were the experts. People who weren't clergymen, they were lay people. So we're talking about a reverend. He would be a lay person in this context. So does that mean he is knowledgeable about this area of law? Personally, I don't think so. But anyways, here is the paragraph from that article. It is not uncommon in dementia to see a preservation of social graces. Indeed, it is easy to miss significant cognitive impairment if formal probing of cognition or rationale for an estate distribution is not conducted. So it sounds like this reverend was relying entirely on George being personable for 20 minutes or so. Often, lay witnesses attest to the lucidity of an individual who is actually suffering from dementia, but who has preserved social graces and can engage in superficial social conversation without being probed. Now, I've actually seen discussion where they say losing social graces is one of the first signs of dementia. So I'm just going with what this particular article says, but maybe there's room for disagreement there. Physicians, even those who have known the testator for many years, are also prone to miss significant cognitive impairment or even frank dementia if based on conversation only and not specific testing. So, given this is a possibility, is it right to expect people with no medical education to be making these determinations for capacity? On the other hand, we do want to know that people are capable of making this decision and understanding the repercussions. So how do we fix this? The will is considered void due to undue influence, but the judge found no undue influence regarding the marriage, which is considered valid. What happens then? So to me, this opinion is absolutely cracked. So all of those warning signs, including her, being relentless in breaking his will regarding the marriage, doesn't matter. The behavior considered undue influence for the purposes of the will is not considered undue influence for the purposes of the marriage. Again, I think that's cracked. It's the same behavior. Okay, so the will is out, marriage is valid. What happens next? Now we have to go to the statute called the Succession Law Reform Act. You'd think this discussion would be under the Estates Act, but you'd be wrong. When someone dies without a will, and that's what this will be treated as with George, he died without a will. He's considered to have died intestate. So under this statute, Section 44, Where a person dies intestate in respect of property and is survived by a spouse and not survived by issue, so children, the spouse is entitled to the property absolutely. So they get the whole thing. Preferential share of spouse, that's under section 45, subsection 1. Subject to subsection 3, where a person dies intestate in respect of property having a net value of not more than the preferential share and is survived by a spouse and issue, the spouse is entitled to the property absolutely. Yeah, fantastic language here. Okay, so what they're saying here is that there's a certain amount, and I'm going to be telling you the amount at the end. Okay, so someone dies, they have no kids, the spouse gets all the property. Someone dies, there's a spouse and kids. Well, if there is no more than that preferential share, there's no more money after that, well, the spouse still gets the whole thing. Okay, so continuing with that same kind of discussion, section 46, subsection 1, where a person dies intestate in respect of property and leaves a spouse and one child, the spouse is entitled to 1/2 of the residue of the property after payment under section 45. Isn't this fun? We get to bounce around different sections. So what that means is a person dies, the spouse first gets that one big chunk, a preferential share, and then gets a further amount depending on how many kids have been left behind. So subsection 2, where a person dies intestate in respect of property and leaves a spouse and more than one child, the spouse is entitled to 1/3 of the residue of the property after payment under section 45. So yes, it's basically double dipping. So where there is more than the preferential share and there are children, the spouse gets the preferential share and a cut of the remainder. What do you think about that? To find out how much the preferential share is, we have to go to a regulation under the Succession Law Reform Act. This regulation is called Ontario Regulation 54/95 General. One difference between laws and regulations is that laws have a longer process to get through. So read 3 times, royal assent. With regulations, it doesn't have to go through that process. A person is identified as having the authority to make changes, and reasons for that include allowing for some kind of fine-tuning or addition or updating things as society changes or what have you. Sorry to get all political here, but when a politician says, I'm just going to get rid of 25% of regulations, I'm fairly confident they don't really understand how many regulations there are under all these different statutes and what they're meant to do. They're not all about creating red tape to make everyone's life difficult. Okay, so definition of preferential share. Section 1, for the purpose of Section 45 of the Act, the amount of the preferential share is prescribed as, so identified as, if you will, A, $200,000 for the estates of persons who die before March 1st, 2021, and B, $350,000 for the estates of persons who die on or after March 1st, 2021. Now, back in 1998, I think the amount was smaller. It was around $100,000, if I remember correctly. So this is what happened. This woman targeted a vulnerable man, isolated him from his family, and got him into a position back then. Will is out of the window and creating a new will. And despite the fact that it wasn't considered valid, she still gets $100,000. This is a con job. And is this something we're going to have to worry about more and more as more people with money get older and they're getting married more often? So what do you think about that? This is the end of the video. Thank you for reaching the end and have a great day.